Good afternoon, everyone. I'm John Ravitz, the Executive Vice President and Chief Operating Officer for the Business Council of Westchester. On behalf of Marcia Gordon, our President and CEO, we want to welcome everyone to our first fall 2021 webinar series. As many of you know, the BCW is the county's largest business membership organization focusing on advocacy and economic development. When the pandemic began, we immediately decided that our most important role we could play on behalf of our members in the business community was to provide daily updates on issues, concerns that businesses needed to know about. And as the months continued to move forward during the pandemic, our commitment to our members and the business community stayed the same. We continued to hopefully be a daily presence in our members' lives, but more importantly, we wanted to make sure that they had the most updated information, hearing from key stakeholders, but also to be industry specific, to be able to present real leaders to talk about challenges that businesses in all sectors were facing during the pandemic. And these webinars have played such an important role in being able to provide those services. I should note that this webinar today, as well as future webinars, will be on our Business Resource Center page. So for those people who cannot have the opportunity to hear it live, they will be able to go back and watch the entire program in its eternity. And also, this is going to be recorded live on our Facebook page as well. We're very excited at BCW because we have two members that not only are leaders within their industry, but have continued to be proactive on behalf of their members and clients during the course of the pandemic. And that's Levitt-Fuirst Insurance and the Builder and Reality Institute, Realty Institute. Our host today and our moderator is Ken Fuirst, who is the co-president of Levitt-Fuirst Insurance, which is headquartered in Tarrytown, New York, with 52 years in business and a staff of 70. Levitt-Fuirst is the largest independently owned insurance and bonding broker in Westchester. It is the insurance advisor to the Builders Institute and has been recognized by Insurance Business America magazine as a top specialist broker for construction insurance. Levitt-Fuirst construction teams focus on providing comprehensive insurance coverage and risk mitigation services for their contractor clients. And their unique benefits for contractors include group discounts on insurance, in-house surety bond underwriting, and even a team dedicated to issuing insurance certificates on demand. Levitt-Fuirst clients include several of the county's largest commercial subcontractors to local trade contractors and suppliers. And again, on behalf of Marcia and myself, Ken, we want to thank you for not only your leadership in Westchester County, but putting this series of webinars together for the business community at large. Ken, I'm going to turn it over to you.
Thank you, John. And thank you, the Business Council of Westchester, for promoting this four-part series. Besides today's OSHA topic, the other three topics will be on September 22nd. We're going to talk about cyber attacks and how they've impacted the construction industry. And we're going to give you actual examples of contractors that have been attacked by cyber thieves and what you can do to prevent and avoid that in the future. On October 6th, we're going to be talking about navigating the permitting and application process, and we'll have some experts that could give you some hints on how to navigate that system. On October 20th, we're going to talk about the legal landmines for the building and construction industries. And as John said, if you happen to miss any of those, you could always find it on the Business Council of Westchester's resource page or on their Facebook page. As John said, all four webinars are being sponsored by Levitt-Fuirst Insurance and the Building and Realty Institute, the BRI. For those of you that don't know, the BRI is a trade association in Westchester County and the Hudson Valley that includes home builders, multifamily commercial, and mixed-use developers, remodelers, and many real estate businesses. They exist, the BRI exists to advocate for the best interest of the realty and construction industries, to the government, to the community, to really help build the business for the whole industry. The BRI provides a significant amount of knowledge and education and resources to their members to help them improve their businesses. If you're not currently a member of the Building and Realty Institute, you can learn more about it at their website at buildersinstitute.org. The Builders Institute is also an affiliate of the National Association of Home Builders and the New York State Builders Association. Tonight's format, we're going to start with Brad Hammock. He's a partner at the Littler Law Firm. His national practice focuses on all aspects of occupational safety and health law. Brad works closely with employers to help them understand and implement safety and health management systems. In addition, he represents employers throughout OSHA rulemaking proceedings, including OSHA informal public hearings on proposed rules. Brad also defends employers against OSHA enforcement actions. And for an employer that is the target of an OSHA inspection, he offers representation from the start of the inspection throughout the settlement or litigation. What we'll do is Brad will discuss how to prepare for an OSHA visit, and then we'll turn it over to Jeffrey Pope, who will discuss some specific case studies of what happens after an OSHA citation. Those of you that don't know Jeff, he's of counsel at the construction law firm of Welby, Brady, and Greenblatt in White Plains since 2004. His practice includes advising clients concerning OSHA matters and representing them in matters with the area offices and in litigation in the Occupational Safety and Health Review Commission. He co-authors and writes on his own the safety policy column in the CIC monthly publication Construction News that he works with Tom Welby. We're going to start off with Brad, and Jeffrey will pipe in and then be turned over to him later on. And then at 4:45, we will open up to any Q&A that you guys have posted on this site. Brad, it's all yours.
All right, great. Thank you so much. Thanks, everyone. It's a pleasure to be here to talk about what is actually a very important topic, and that is how to deal with OSHA and site safety and how to prepare for an OSHA inspection. Really pleased also to be joined by Jeffrey, who is an expert, particularly up in your all's neck of the woods. And so it's not very often that I get the benefit also of listening to another practitioner and getting a little insights into how things work, particularly up north. So it's a real pleasure to be here. And as was just stated, look, if you have any questions as you're listening to this, type them in. We're happy to answer all that we can, and look forward to a nice discussion. So let's get going. We don't have a lot of time, but what do we want to talk about today? Well, there's several parts to this, right? I mean, we're sort of talking about how to, work site safety, how to handle OSHA, and there's several, sort of components of this. The first piece is how to prepare for an OSHA inspection, right? The key thing in terms of navigating an OSHA inspection and navigating one successfully is to be prepared at the outset, right? Obviously the one thing that sort of goes without saying is, hey, you should be in compliance with all the relevant OSHA standards, right? You need to be sort of just thinking, what can I do to best prepare should an OSHA compliance officer show up on one of my job sites, right? So we're going to spend some time talking about the preparation stage of this. And then we're going to segue a little bit into managing the OSHA inspection process itself. Okay. OSHA compliance officer shows up at your job site. What do you do? What should you do? What are the things that you shouldn't do? Right. I get a question all the time. Well, should I just pack up all my workers and send them home? Right. And then leave the compliance officer sort of standing there on the job site. Right. So we'll talk a little bit about managing the OSHA inspection process itself. And then finally, we'll kick into some post-inspection considerations, and particularly get some of Jeffrey's insights into what happens should you get some citations, what is the best approach both to handle the issue informally, but then potentially to contest. And so we'll talk through that as well. And so hopefully at the end of this, you'll get a pretty good sense about, number one, preparing for an inspection, managing it, and then what happens if you do, unfortunately, get some citations stemming from an OSHA inspection. Okay, so let's start. Preparation, that's the key. You know, how to prepare for an OSHA inspection. What do you all need to do to be in a good spot should OSHA come on site, okay? And the one thing that I would emphasize, obviously, is that the more you're prepared for an OSHA inspection, interestingly, probably the least likely it is that you will get an OSHA inspection, right? The more that you're prepared, the more that you think about it, the more that you train your workforce on it, the more that you're in compliance with OSHA standards, the less likely it will be that OSHA will actually come on site to conduct an inspection, right? So what are those things that you should be doing to best be prepared for an OSHA inspection? Okay, here's the list. We got about 2 sort of pages of bullets on this list. And I would, you know, sort of, if there's one take home that you take from this is, you know, go back with your safety folks, the people that are in charge of safety of your organizations, and go through these couple of PowerPoint slides with them, see what they're doing or what they're not doing in terms of overall preparation. So the first thing is obviously you got to comply with applicable safety and health rules and procedures. That's number one, right? You should all obviously be familiar with the construction standards that are applicable to your jobs, and you should have a compliance strategy for them, right? The second is you should have some type of overall safety and health program, right? Some sort of overall approach to safety and health that integrates managers and employees in the safety and health efforts. The reason I emphasize managers and employees is OSHA really likes to see employee involvement when they conduct inspections, right? When they're doing some sort of inspection into your job sites, if they get the sense that employees are involved in safety and health and involved in your safety and health program, it will make the inspection go a lot more quickly and efficiently and easily. OSHA loves employee involvement. They love employee engagement. You also have to coordinate your use of subcontractors and ensure that your subcontractors on your sites understand your compliance expectations. You need to have some degree of communication with your contractors and subcontractors that you're using on site. Okay. Now, the extent to which you communicate with them may differ depending upon the type of work you're performing, but you need to have some sense about what your subcontractors are doing with respect to safety. Here's a perfect example. Let's say you're a general contractor. You're doing some home building out someplace up in New York. You're using some subcontractors to do some roofing or even some framing, and guess what? Those subcontractors are up on roof or up at heights and are not tied off. OSHA compliance officer drives by, happens to see folks that are up there not tied off. Guess what? They could open an inspection with everyone on the site. Well, not because you did anything directly wrong, but your subcontractors did, right? So you've got to be sure that you understand what your subcontractors are doing and communicate with them. You obviously have to establish some sort of system to periodically monitor performance and address safety and health issues. And of course, the other thing you have to do is make sure your OSHA record keeping is up to date. One of the things that we'll talk about as we get into managing the OSHA inspection process in particular is that OSHA is always going to ask for your 300 logs, right? So it's very good up front to have good logs, professional looking logs. Those are the first things that OSHA is going to look for and request if they were to conduct an inspection. And as a result, you need to make sure your OSHA record keeping is tight, that it looks good, it looks professional, and is accurate. It's like the old adage, your mother used to say, you never get a second chance to make a good first impression. OSHA record keeping is the first impression in an OSHA compliance inspection. And so you need to make sure that you are following that and tracking that, and that your OSHA logs are professional and look good. Okay, so those are the first building blocks, right? The basics for being prepared for an OSHA inspection. What is the second thing? Okay, you have to, or you should at least, develop a protocol for handling an OSHA inspection. That is key preparation step number 2. You need to have thought about everything Jeffrey and I are going to be talking about here for the next 30 minutes. You need to be thinking about that and have thought about that in advance, okay? Some of the things that you need to include in your protocol are set forth on this slide, okay? What type of access are you going to grant to a compliance officer? I mean, I get a question all the time, you know, are you going to demand, should I demand a warrant of a compliance officer if they come onto one of my job sites, right? You know, get off my job site, go get a warrant, right? Some employers swear by that approach. Some don't. But whatever your approach is, you need to have thought about it ahead of time. The worst thing you can do is to sort of have one of your, you know, job site foremen, you know, kick a compliance officer off the job site and request a warrant when that's not what you want to do, right? So it's really important that you have and thought about that in advance. Include it as part of your protocol. Who's going to interact with a compliance officer? Generally, it's going to be the foreman in the site, but not always. You need to think about that. Include that in your protocol. Who's going to accompany the inspector during the walk around of your job site? Again, there's no right answer to some of these questions, but they're important questions to think about and to consider ahead of an OSHA inspection. How are you going to handle the work when it comes in, right? Are you going to continue to work with the compliance officer on the site, or are you going to leave the job site, right? I mean, some employers do that, some don't. You need to think about that in advance. And then you need to think about things like, hey, the compliance officer might interview managers, might interview employees. How is that going to happen? Who's going to be participating in those interviews, if anyone, right? All of these things you need to think about in advance of an OSHA inspection, and then you need to include it in your protocol for handling an OSHA inspection. And then once you have developed that protocol, right? Once you have developed that protocol, you have to train your folks in it, okay? So all your foremen should be trained on what to do should OSHA come on site, but also what your protocol is for handling an OSHA inspection, right? All of these things need to be thought through upfront in advance, and your folks need to be trained in that as well. The other thing that I would note as a general matter is you're going to want to make sure your subcontractors also have some protocol in place and are acting in a way that's consistent with how you would like an OSHA inspection to take place as well. Okay. So that's the preparation process, right? Pretty easy, right? Think about things in advance, train your folks in advance, et cetera, right? So pretty straightforward. All right, let's segue though now into managing the OSHA inspection process, the nuts and bolts of the OSHA inspection process, right? So OSHA comes in on site, maybe they're driving by, maybe they see someone up high with not tied off, whatever it is, and we'll talk about the reasons they could come on site. They start the inspection. And so how do you manage that OSHA inspection process? Okay. The first thing you've got to think about in terms of managing an OSHA inspection is, why is OSHA there in the first place, right? That is key to managing the inspection. Why? Because as you see on that final bullet there, the type of inspection establishes the inspection's scope, okay? The reason that OSHA is there is going to be what dictates to what extent OSHA can conduct an inspection and what they can look at and what they can get into, right? Everything is driven about why they are there, okay? So on this slide, I've listed the primary types of inspections that can take place, right? One is an imminent danger situation or an accident and fatality. You know, you report something to OSHA, you know, again, God forbid there's a fatality or a serious accident, you have to pick up the phone and call OSHA. That may trigger an OSHA inspection. Complaints or referrals. Everyone knows that employees have the right to call OSHA and complain about an unsafe condition, right? Well, sometimes those complaints get handled through a letter, you know, it's called a phone and fax system. But oftentimes they'll result in an on-site inspection. So that complaint could trigger OSHA to come on your job sites. There are special emphasis programs. These are sort of national programs or local emphasis programs that OSHA puts out that helps to drive their inspection resources in certain areas. That is another way that OSHA could come on site. Follow-up inspections. You know, maybe OSHA issued you a citation 6 months ago and they're just following up to confirm that, abatement has occurred, right? So all sorts of different things. And then the last one that I always point out, because the beauty of being in construction, right? You're in construction and you do a lot of work outside, you get that fresh air, but it also runs the risk of OSHA driving by and seeing something that it believes is a potential violation. And that could be another reason why OSHA comes on site to conduct an inspection. So you've got to kind of figure out why they're there, and that will help dictate to you how you're going to handle the remaining components of the inspection process. And it really dovetails. It really dovetails into what you do when the compliance officer arrives. I was just talking about here, the type of inspection establishes the inspection scope. Well, when an OSHA compliance officer comes onto one of your job sites, the first thing you're going to want to figure out is, why are you here, right? Why have you arrived on my doorstep, so to speak, and asked to come here? It is critically important that you identify the very earliest you can why they're there. Okay, so typically what's going to happen is the compliance officer is going to get there, the compliance officer is going to arrive, and the compliance officer will identify himself or herself and oftentimes present credentials. Okay. They actually have badges, right? If you've never been through an OSHA inspection, they also have, business cards, and they'll typically leave that behind. You want to make sure you clearly get the compliance officer's information. I know it's hard to believe, but I've been involved in some inspections after the fact, and I'm talking to my clients and asking them, hey, who is the compliance officer here? And they actually don't know the compliance officer's name. So it's really important up front that you identify who the compliance officer is, and make sure you get all of that information in play. I've got a bullet here that says you're going to make sure you follow your written plan, right? Well, we've talked about coming up with that written protocol, that written plan in place, and you're going to want to make sure that that's in effect when the compliance officer shows up. The other thing that's really important is you're going to want to think about up front where you can take the compliance officer so that it's outside the view of the work site. The compliance officer is going to come into the work site and going to present their credentials. You need to have a good, conversation with the compliance officer up front, and you're going to want to do so in a place that is generally, outside of where work is being performed, where you can have a serious conversation. You obviously don't want the compliance officer just poking around early on until you've had that opening conference. And obviously, you should note that the compliance officer is allowed to expand the scope of the inspection if they see alleged violations in plain view. So, you want to be careful of that. You want to be thoughtful about that. And you just also want to be in a position where you can have a good, I would call it a quiet conversation with the compliance officer, not with a lot of work that's going on around you. So after the compliance officer comes on site, and I said you kind of bring them into an area of the work site that is a little bit out of the way of where the work is being performed, the compliance officer is going to hold what's called an opening conference, okay? In that opening conference, the compliance officer will explain the purpose of the inspection. Why are they there? If for whatever reason the compliance officer does not, then you're going to want to elicit that, right? As I said, it's very important at the very outset that you know why that compliance officer is there. That will dictate, right? That will dictate the scope of the inspection, okay? So you're going to want to make sure you get that information as much as possible in the context of the opening conference, right? Obviously take notes. Document what the compliance officer says. Why are you here? Well, I'm here because an employee complained about the fact that you didn't have enough bathrooms at the job site, right? Okay, that's why you're here. All right, record that. And so now as the inspection progresses, you keep that in the back of your mind that that's what the inspection is limited to. Okay, that's what the inspection is limited to. So it's important that you understand that at the very outset, right? Take good notes. Make sure you fully understand and make the compliance officer be as specific as possible regarding why he or she is there for that part of the inspection. Okay. After the opening conference, okay, OSHA is going to do what's called the walk around, and this is the portion of the inspection that everyone sort of knows about, right? Generally, OSHA wants to get to the area of the work site that is at issue. They want to see what's going on. If there are people up at heights without fall protection, they're going to want to go out there and look at that, right? Generally, the compliance officer is going to move fairly quickly into the walk around portion of the inspection after the opening conference. A couple things to keep in mind as an employer. You're going to want to have someone designated to accompany the compliance officer at all times, someone that ideally that's familiar with your operations, familiar with how you approach safety. Depending upon the makeup of your workforce, OSHA may ask to have a union participate, or some other safety committee member, some employee representative participate in the walk around portion of the inspection. Okay. One thing to keep in mind, as I said just a little bit ago, look, the compliance officer is going to be inspecting at all times. So, you know, when you walk to a certain area of the work site, he or she is going to be looking around. And so if you have hazards that are, you know, out there and that are easily seen, OSHA can expand the inspection to deal with those things. So you got to be prepared for that, right? You got to be prepared for that. You have to answer OSHA's questions, obviously. You know, it's important that you understand, right? It's important that you understand what OSHA is going for, what they may be looking for, and have your designated representative, be knowledgeable about that, right? So look, if someone's coming out and the compliance officer understands that you don't have enough bathrooms, we need to have someone, you know, who understands and can communicate things with OSHA in a way that obviously advances, you know, your interests and makes it clear that you know what you're talking about, right? You take safety seriously. You've got a protocol in place. You're in compliance with OSHA standards. But one thing I would note is you never want to admit a violation. And I'll be interested, you know, as when we segued over to Jeffrey about how that plays out, you know, after a citation in an informal conference. Because in some instances, that may be a different consideration. But at the time of the inspection, you never want to say, hey, oh, you're right, you got me on this one, right? Even if you think that's the case, because you may have defenses to something. It may not be a violation. But you obviously want to take notes. You want to be respectful of the compliance officer. But you don't want to just sort of sit there and say, oh, yeah, you got me on this one. Oh, yeah, this one should have been grounded, et cetera, right? So, you know, keep that in mind. It's obviously an important part of the inspection process. You know, take detailed notes of what the compliance officer does. The compliance officer will typically take photographs, maybe some measurements, and so on and so forth. You're going to want to take notes, you know, do the same thing. I often say, look, if the compliance officer takes a drink of water at a water fountain, you go up and you take a drink of water at that same water fountain, right? If the compliance officer takes a picture of your fall protection, you know, we all have phones now. You could just take a picture as well. You want to document as much as you can, right? What the compliance officer is looking at and thinking about. So afterwards, you can sort of revisit that with your internal team and help determine how to further manage the inspection process. One thing that I would say is if you have a compliance officer ask you to demonstrate something, be very careful about that. You know, sometimes something will have happened at a job site and the compliance officer will say, hey, can you just recreate that? I've actually had that with some construction clients before. They want, you know, my clients to recreate what happened. Be very careful about that. Obviously, if there was a hazardous condition, you don't want to, you know, recreate the hazardous condition, that's for sure. But just in general, it's not a good practice to try to recreate or redemonstrate to a compliance officer what may have happened, okay? After the walk around, the next part of the OSHA inspection process, and I alluded to this at the beginning of the presentation, is management and employee interviews. Typically, OSHA will want to speak to both employees and managers about the safety and health conditions at the work site, right? Couple things to keep in mind. OSHA takes the position that employee interviews are in private. And so generally, OSHA will conduct those in private. Ultimately, it's the employee's decision as to whether they want to be interviewed or not. But OSHA typically wants those to take place in private. With management personnel, however, supervisors or legal representatives can be part of those interviews. And so you'll want to make sure that as a practical matter, you're thoughtful about those and you have another representative sitting in on those particular interviews. A couple other things before we get to the point where hopefully we've received no citations, but you might. Request for documentation. Typically after the initial walk around, OSHA may request certain written information. That is very standard. When they do that, a good practice is to ask for them to do so in writing. Go ahead and shoot you an email to that effect, at least, just so there's complete clarity as to what they want. And so you have it in hand and you can be super responsive to them. It really doesn't, it doesn't do anyone any good for there to be ambiguity as to what OSHA wants and what OSHA doesn't want. And so if you're in an inspection and OSHA request records, you should, if at all possible, get that in writing and then review your documents in advance, right? Look at them, gather them, be thoughtful about them, put them in a cover letter, whatever that looks like, you're going to want to sort of be organized about it. Again, part of the OSHA inspection process is looking professional. You take safety seriously, right? You're a professional organization. You need to make sure that OSHA understands that. And then finally, at the end of the inspection process, it's a closing conference, what we call the closing conferences. And this is when OSHA goes in and says, look, okay, we looked around. I was very impressed, Mr. Employer, about your protocol. You were very professional. I only identified a couple violations. Here's what they are. You did a great job. You must have listened to Brad and Jeffrey on this webinar. But, during that conference, if there are some alleged violations, they will let you know what those are, right? Generally, these are not final at this point. And also, OSHA generally won't give you what the proposed penalties are, but they will tell you, right? They will tell you, kind of what to expect, right? You're going to get a violation for fall protection. You're going to get a violation for personal protective equipment or whatever it is, right? And so that's the inspection process, right? And again, you hope that you're prepared. I hope after this, you're certainly prepared. But sometimes, right? Sometimes the best laid plans, you still don't necessarily get off citation free. And that's where Jeffrey comes in, right? Because what happens is you may get a citation, and then you have to think about what that means, right? What that means for your organization, what you should do at that point. And Jeffrey's going to sort of take it from here and kind of walk through, particularly in your local area, what's the best approach, right? You get the citations and boom, what do you do? So Jeffrey, I'll let you take it from here.
Thank you very much. It's a pleasure to be here today, and my thanks to the sponsors for having me. I don't do a lot of online teaching, so I'm not going to match Brad for fluency, but I'm going to try to give you some pointers that will be of help to you. First, a few words about the degrees of violation. You are likely to get a citation, and if you do, the various violations will be classified as serious, willful, repeat, or other than serious. And the two critters you really want to avoid, or if possible, negotiate downward, are the repeat and the willful, because these not only cost you 10 times as much, the maximum penalties being over $130,000 per item, but they're also a real blot on your record. And it could become hard for you to get hired by construction managers or by even to bid on certain public jobs if you have a big accumulation of serious violations, or even as few as one willful violation. You should be aware also that while you may try to bargain serious items down to other than serious, a category that is really kind of reserved for things that aren't greatly dangerous or even petty paperwork violations, you should be aware that even an other than serious violation, can be a predicate for a later repeat violation, which again has a big penalty and can be really problematic. Also, a repeat can be based upon the violation of not the exact same standard, but one in fall protection or related standard. Now, when you're cited, the first thing you need to do is to make sure that you know when the citation was received in your office, because you've got 15 working days, which means days other than weekends and federal holidays, not Good Friday or Tisha B'Av or whatever, but you've got only 15 days to send your notice of contest to the area director. And if you miss that deadline, your goose is cooked. The citation is going to become a final order, and you're in a very difficult situation. You can make a motion, but these motions are made all the time and they're almost never granted. So this is particularly important if you're a small organization and you sometimes shut down certain times of the year and maybe don't have full-time staff, because you have to make sure your mail is conscientiously handled and that the citation comes to your attention promptly. Excuses are seldom going to fly, and that can be a real problem. Now, the next thing that you need to do is take a deep breath, because you're not the only contractor who's been cited. If you're in construction and you're going places, you're going to get some mud on your boots. So if this is your first citation, you should thank your lucky stars, because construction is inherently dangerous and you're a target, especially if you do larger jobs. So then, after taking a deep breath, you should call an attorney, because you're almost certainly going to need your lawyer's help in dealing with this citation. So then, if notified in time, the lawyer can help you draft a notice of contest, which you should be ready to send even if you have the informal conference. And if you do it yourself, make sure it's on the letterhead of the cited entity, that it refers to the inspection number, and that it states as to each citation item that it is disputed as to whether or not there was a violation, whether the appropriateness of the dollar amount of the proposed penalty, and the appropriateness of any date set for the completion of any abatement that they may demand. Now, this doesn't get sent to the Occupational Safety and Health Review Commission in Washington. It goes to the area office. But before you serve a notice of penalty, a notice of contest, in nearly every case, you're going to want to have an informal conference with the area director. And this may or may not succeed in the resolution of the entire matter, with some concessions by OSHA as to the severity of the penalties or the classifications, et cetera. But even if you don't succeed in that goal, it's almost always worth doing in order to fly the flag. As Brad pointed out, it's really important to appear at all times to be respectful of OSHA and to be a safety conscious and responsible employer who has a good record, or if you don't have the best record, that you're making earnest efforts to improve, that you train your workers conscientiously, that you enforce your work rules, and that you got religion, even if it hasn't shown up yet in terms of your overall history. So since you've only got 15 days to serve a notice of contest, you need to move quickly and to schedule it no more than a couple of working days down the road. And because you need to have a plan going into the informal conference, you're going to want to have the cooperation of a competent, experienced lawyer to do that. Be aware also that fixing a date for the conference doesn't extend the 15-day period. So you got to get it done and finished before the time comes to make sure that that is in the mail. So if you're going with the proper approach, you're going to get something. Maybe you're going to get some real concessions. And really, this is probably your best opportunity, especially in the absence of strong legal defenses, to negotiate a favorable settlement. And if not the best, probably the most cost-effective means of getting a good outcome. So since the proposed penalty amounts will usually have been fixed with due regard for the size of your company and your past record, et cetera, if there's only a single item in the citation and you're dead to rights, I mean, if it's really pretty clear that it happened and you don't have a real good legal defense, that's going to be the hardest one to negotiate. And since they increased the penalties, the dollar amounts greatly, well, if there's a silver lining in that, it's that if you get a multi-item citation, it may be that you can get 2 or more items combined. For instance, you may be cited for a substantive violation. You may also be cited for a failure to train as to that hazard. And if you've got a good record and you show yourself to be a conscientious employer, they may say, fine, we're going to make this 1 serious item rather than 2, and we're going to cut the penalty substantially. So at all times, again, your attitude is critical. And if you have any complaints about the inspection, the informal conference is not the time to raise them. And if you have a general attitude that OSHA is an infringement on free enterprise, you're not going to raise that at the informal conference either. You should probably keep that one to yourself. You should consult with a lawyer. You should decide who's going to come with you, the lawyer, probably your safety manager. The hardest call may be whether or not you take the foreman who is in charge. If there's a real question as to what really happened, you may want to try to bring him, but it's also a situation that may be fraught with peril, because it may be that the foreman is a whistleblower who, as you will unlikely learn until the eve of trial, he may have called it in. He may be the guy who tipped off OSHA to come and inspect you. So it's also kind of precarious, because sometimes foremen and your lower level employees sort of calculate their responses to based on the authority figure and who they perceive to be the bigger dog. And it may be that while they told you that nothing really happened and that the compliance officer is picking on you, it may be that they made really damaging concessions in private interviews with the compliance officer. You may not see them ever, or at least until much later in the proceeding. So that one is pretty dicey. So if you have a safety manual, bring it with you. If you have a job-specific manual, bring that with you too. And anything that you can do to present as someone who really works hard at safety, the better. Now, be aware that even before COVID, our local office in Terrytown, New York, was conducting a lot of these informal conferences by conference call. And that really isn't as good in my estimation, because you don't get to read people's body language or give each other visual cues, but it is what it is. And if they insist upon it, or with COVID, that's all that is available, that means you even have to have your presentation better planned. And you might want to cut the complement of people that you take with you, because only 1 or 2 people are going to be able to say anything. So at the conference also, if there are any strong legal issues that are jumping out at your lawyer, like whether or not you could reasonably, as the employer, be aware of the violation, which is a hard nut to crack if there was a supervisor present at the time that it happened. But if there's something obvious, a legal basis, well, if OSHA feels that they may have more trouble winning a trial, they might be a little bit more inclined to cut you some slack at the informal conference, because OSHA is understaffed. They don't have the ability to litigate all the cases. They want to get a decent result, collect some penalties, punish only the bad actors unduly, and they want to move on probably almost as much as badly as you do. So a speedy compromise is often something that they will be amenable to. If you go with a decent safety record, if there are multiple items, if there's a little room for them to do some horse trading, they're likely to give you something. And if you want to offer additional training as to other particular hazards, that's something that will also, again, underscore your commitment to safety and make them more likely to give you a deal. When there are concessions on the table, the great expense and uncertainty of litigating and going to trial should really weigh heavily and should tempt you to take even less than an ideal, quick, cheap resolution. But in any case, every citation is an opportunity to see the weak points in your performance, see what you can do better, to take stock and try to maintain and improve your relationship with OSHA, because you're going to be seeing them again if you remain in business. And if your record of past violations is not the greatest, you need to show that you've got the true faith and you're going to be working hard in the future. If nothing is offered or you're dissatisfied with the offer, it still behooves you to conclude the informal conference cordially. If you're convinced that you want to turn it down, you might want to have your lawyer to phone that in the next day and at least leave the meeting on not a negative note. So let's assume that you failed to reach an agreement, that you have not succeeded in resolving the entire matter at a an informal conference. Then you have to file the notice of contest within the 15 days. And though what happens then is that the case moves out of the OSHA area office and it goes to Washington, D.C., to the adjudicatory arm, which is the Occupational Safety and Health Review Commission. It was set up by Congress back in the days when the Republicans and the Democrats somewhat worked together. They gave it some independence from the OSHA, who were like, the hammer and tongs. The commission itself has 3 members, and they often serve as a sort of appellate tribunal, but you're going to be dealing with an administrative law judge. And they have a cadre of these judges who don't have, it's not the greatest judicial appointment. They don't have elaborate chambers and lifetime appointments and big salaries, but they travel around the country and they try these cases. Most of the pretrial proceedings are conducted remotely by conference call. And one of the more perverse features about OSHA from a lawyer's standpoint is that the appellate precedents can really be complicated, because the commission itself has precedents, and as many as 3 different courts of appeals may have jurisdiction, and they may not have consistent rules. So because so many rules are left up to judges, they're not in the statute, they're not in the rules of procedure that the commission has for itself, sometimes you just don't know how they're going to come out on what may be outcome determinative issues. I'll give you one example of those later on. So once the commission gets your case, the Secretary of Labor has 20 days to serve a complaint, which it's a formal legal document. It sort of sets things rolling, and it needs to give you some specific information, most of which is pretty redundant of what's already in the citation. Then you kind of have to decide, do you want to fold your tent quickly, pay some penalties, and move on, or do you want to head down the road towards a trial? Be aware, this is seldom quick, it's seldom cheap. It often goes on for a year, sometimes for more than 2 years, and good results, they can be obtained, particularly when you've got a good legal defense, and it's not a question of a self-interested evil contractor or a furtive employee who probably screwed up and is covering his backside, being believed over a dedicated public servant in the person of a compliance officer. So if there's a bias in these proceedings, is probably on the he said, she said questions. So generally, the rules of civil procedure are going to be followed, complemented by some procedural rules set by the commission. There is a creature known as simplified proceedings, but you're probably not going to get there because it's limited to straightforward, legally simple cases involving small amounts of money and no repeat or willful citations and no fatalities. So if it's worth litigating at all, you're probably going to be in a bigger dollar category and you're not going to go there. So after you put in your legal answer, or your attorney does, asserting any affirmative defenses, again, the pretrial discovery schedule is going to be set by the judge. There's usually some streamlining. It's not going to be quite as extensive as if you were in a $10 million civil case in federal district court. But still, it's not uncommon that there will be multiple depositions, potentially some motion practice. It's expensive. So then you have to consider again, what are the pros and cons of even going there? And there are some pros. And one is that the work at the local level, with all respect to Tarrytown, with which we've had pretty good dealings down the years, the work is uneven. The directors and the area assistant directors are usually pretty good. The compliance officers, it's a tough job because they're not greatly well paid. They encounter hostility at every stop, and they tend to be a little prickly and a little combative. And if you move out of the area office and you go to the solicitor of labor, which is the cadre of attorneys who represent the government in these proceedings, then you're going to get a new set of eyes. And they're not going to be as personally involved. They're not going to feel that their manhood or their integrity is being placed in issue, and they may be more reasonable, or at least they may have give it a fresh view. A second positive, or at least the absence of a negative, is that while you may fear that you're walking into a kangaroo court, well, there are disadvantages, but the administrative law judges, by and large, are not really among them. They're really surprisingly good, especially on the law. And I have only modest experience in litigating these cases, but I read boatloads of decisions, and they're very knowledgeable. They're even downright scholarly. And by and large, I'm quite impressed with them. So I've read hundreds of these decisions, and so it's not that bad. Sometimes you may be in danger of not being able to get additional work. So if you've got even a halfway good defense, you may really have little choice but to litigate it. And that can be a very tough situation to be in. And finally, there can be some satisfaction in having your day in court, but at the outset, principle is a great thing, and wanting to fight, I've got a combative spirit, but your lawyers are going to be paid privately. There is a paucity of good lawyers who are experienced at this. Your brother-in-law who does house closings ain't going to cut it. And even somebody who's somewhat knowledgeable is going to be outgunned, because the attorneys who represent the government, this is what they do. They're highly specialized. They may not be the creme de la creme, but they're very workmanlike. They're very knowledgeable. And so you're going to be at a disadvantage. And they're working for government salaries. You're going to be paying private hourly fees. And another factor is that there are procedural issues that favor the government. Hearsay is easier to get into evidence. There are whistleblower protections. You may not learn about things that were said by your employees, except maybe if they're going to testify, you might get it at the last moment. And even low-ranking employees' admissions may be binding on the company, because it's pretty ample under the federal rules whose admissions may be party admissions. So you need to also, if I can give the one example of the legal complexity, there is traditionally in many courts, the difference between a serious and a willful violation is that a willful violation required an element of deliberate disregard, a real kind of bad act on the part of the employer. But there's always been a contrary view, which in recent years has gained ascendancy, which is that if you got anybody who's a supervisor, even a humble lead man, anybody who can tell anybody else what to do, certainly a foreman, and if he or she proceeds to a violation knowing that he's deeper than 5 feet in an unshored trench or whatever, that's a willful choice. And that may bind you and subject you to $130,000 in penalties. And so you really need to impress upon all of your supervisors, however humble, even if they're, again, union guys who are running a 3-man crew, that they may really be able to bind the company, and that they need to be conscientious, and they need to be very careful and never violate OSHA. I mean, that's really what it comes down to. They have to observe all the standards. So again, over the years, I've read all these cases. They will seldom be won because the judge disbelieved the compliance officer and believed your witness. So if it's he said, she said, that's all the more reason that you want to try to get this resolved early on at the preliminary conference, I'm sorry, the informal conference, or very early in the litigation stage. So these, a final consideration is that I don't think OSHA is angered if you litigate a solid defense. But if it's really kind of spurious, or if it's the often asserted but seldom won unpreventable employee misconduct defense, which really requires a lot more than the breaking of a work rule, it's not going to ingratiate you with the local office, and it may really impair that relationship. So if you've got a good defense, go ahead if you're otherwise disposed to do so. If you don't, again, you probably want to settle as quick as you can. So while there are occasions,
Jeffrey,
I'm done. I'm ready to go. Thanks.
no,
My last sentence: litigation should be a last resort and few and far between. Thank you.
No, thank you. And you and Brad have given some very helpful information. We only have a couple minutes left. And just, Brad, I'm going to toss to you I'm going to combine a couple of questions into one. People paid big bucks to attend this seminar, and you alluded to being prepared for the visit, and what so that the contractor knows what to do when OSHA arrives. But you didn't give any answers of what you would recommend. You just said you should be prepared, but everyone wants to know, should they request a warrant? Should they ask their workers to leave? Should they, speak with OSHA? Can you just give a quick minute of that, and then we will turn it, and then we will conclude.
Sure. Yeah, no, I try to avoid giving any answers, right? Just teeing up the questions. In general, I think most employers that I work with take a middle of the road approach with OSHA. They don't demand a warrant. They try to cooperate with the agency. As Jeffrey and I said, be respectful and professional. I don't think generally, if OSHA shows up, you send all your workers home is necessarily a good way to proceed, because I think it makes OSHA be kind of suspicious, what's going on. I want to talk to some of these people, and you've sent them all home. It also has the impact of probably having OSHA come back. And, in part, you kind of want OSHA to be there, do that, and move on, right? So, in general, I think I generally counsel clients to be middle of the road. You have your rights, and you need to be willing to assert them, but also getting into it with OSHA on, every sort of point of order, I think in the end probably doesn't serve most employers well.
Great. Thank you, Brad. John, thank you for hosting this. We know people will find this information extremely helpful.
Ken, thank you. And I want to thank Brad and Jeff. In my old days when I was the CEO of the American Red Cross in Westchester County, our motto, our biggest obstacle was denial. People thought things like this could never happen to them. So again, I think the lessons that we've learned today from this webinar will be very important. And again, this will be on our Business Resource Center page. So please refer people to that page so that they can really get that key information that both Jeff and Brad supplied today. And again, I want to thank Ken and Tim and their organizations for continuing to be leaders in the county.
Great. Thank you. Thank you, Jeffrey, and thank you, Brad.
Thanks all. Appreciate it. Thanks for having me.
Thank you.